Okay, I'd like to call to order Town of Shelburne Development Review Board meeting for Wednesday, March 26th. As always, I'd like to open up for public comment from the audience. All right. I would like to remind everyone, if you're going to testify, please sign in so we have you on record doing such. Going through the board, are there any items that we need to recuse ourselves from due to conflict of interest?
I'm going to continue to recuse myself from item 10.
Likewise for myself.
None.
Any others? All right. Very, very good. There are no minutes to approve, so we will move right on through. Yeah, why is that? Just didn't get in time?
Yeah.
All right, so next week we'll have 3 sets?
I got the 20th one the day after I sent out the mailing.
All right.
Yeah.
If you want, I can email.
Okay. So let's, if you could email as soon as possible while it's fresh in our minds.
Well, you have.
Yeah, I have.
All right, then let's do that, and then we can.
From which meeting?
But what I'm saying, do you want me to email them from me, or do you want me to go?
Let's keep Robbie as central control. It'll work out well. And as I recall, we had some modifications from the previous ones. Great, okay, super, okay.
Okay, thanks.
All right, thank you very much. Any other open comments from the board before we get rolling? Okay. Starting out, application A17-12, hearing on the remand per judge order issued by the Superior Court Environmental District. Judgment order addresses Nathan Burr's appeal of Assistant Zoning Enforcement Office denial of application for a zoning permit. Property is located at 499 Beaver Creek Road, is in the residential district and stormwater overlay district. All right, so as customary, Ravi, I see we have a, if you can get us started, I see we have a rather large packet of paper. So kind of get us all up to speed on where we were. And
Right. This item was previously heard on December 19th, 2018. From that, the board issued a decision regarding the motion to compel by the appellant. Part of that decision also included a return to the hearing on this date, March 6th, 2019. Part of your packet includes the record from that was given to you December 19, 2018, and also 2 new items for your review. One is the email from Dean Pierce, Director of Planning, Town of Shelburne, to the appellant, following up on the motion to compel by the board and the decision by the board. And the second item is the decision issued regarding the motion to compel that was signed in late January. I forget the exact date, but late January. Regarding procedures, this is up to the chair. Standard rules of procedure are the Development Review Board's Rules of Discovery and Evidence, and also the Rules of Procedure and Conflict of Interest Policy. Staff would suggest hearing opening remarks and then following up with an inquiry into the matter of the remand.
okay. Very good. Opening remarks? Thank you. I suppose I should.
So I know there's at least one new member, so just briefly by way of background.
Yeah, I
Oh,
have to do that. Thank
yes.
you. Hang on, we'll wait till. Don't want Ravi in the way of the swearing in here. No worries.
Amelia, this is plugged in, right? I haven't touched that today. Oh, okay. Never mind.
You lost it?
I lost it.
All right, so let's swear you in so you can talk while he's filling fit. Ready? Do you swear to tell the whole truth, nothing but the truth, under pains and penalties of perjury?
I do.
Thank you. For your record, can you state your name for the record?
Nate Burris.
And Celeste Burris.
Thank you very much.
So just very briefly by way of background, I grew up here in Shelburne. I think we're sitting in my 3rd grade classroom right now. I worked here for the town during summers between college in the maintenance department, vacuuming this building and cutting the grass. And so I was in Boston for about a decade and then moved back in 2017, purchased the home that is the subject of this appeal, and I just wanted to briefly introduce myself. I don't know if it makes sense now to go just briefly
So the
into.
first question is, the town was supposed to produce for you records. Did you receive those records?
I've received a record, yes.
Okay, one record. Okay,
I think we have differing interpretations
Okay.
of the coverage of the court's order, which I'll get
we'll
to.
wait till
but,
Rob, I want to make sure Robbie's good.
we did receive access.
No, okay, so that's good?
Is that good? Your vision's better than mine.
Yeah, oh, yes, absolutely.
yeah,
That's
yeah.
good, that's good, all right.
Okay.
Okay, so the question I was asking is, did the town deliver what it was asked to deliver?
Based on the records that I have, yes.
Okay.
But this can be stated by the appellant and
course,
appellee for
okay.
further details.
Okay,
So in addition to affirmatively providing a record, the DRB's prior decision on the motion to compel gave us access to other town records. What we'd like to do today is move to admit those records for your consideration. What I'd like to do now, if the board is so inclined, is to give you copies so you can see what I'm seeking to admit. I'll
Okay.
go through what they are, and then you can make a decision whether or not you want to admit
Okay.
them. So I have individual copies here for each member.
Could I ask the chair to inquire of the town attorney if there's an objection to us seeing these documents? To seeing the documents? No.
Please do take into consideration the Shelburne's rule of discovery and evidence, as you do have the authority to admit or not admit these items as evidence.
correct.
So essentially, these are permits related to structures, both fences and other structures in the, I guess what has been referred to as the PUD periphery buffer amongst various PUDs in Shelburne. We've created an index to sort of guide you through what is contained within the packet. In addition to permits, there are other records that show structures within the periphery buffer that have not been permitted. And so I'll go through this just briefly chronologically to sort of show you what is within there. In 1998, there was a permit for 88 Deer Run that was granted for a fence 2 feet from a PUD boundary line. In 2000, at 95 Chesapeake, a permit was granted for a fence right on the PUD boundary line. Also in 2000, also on Chesapeake, a permit was granted for a fence 4 feet from a boundary line. 2001 at 336 Mac Farm, a permit was granted for a fence within the PUD periphery buffer. 2002 at 44 Fieldstone Way, a permit was granted for a fence 20 feet from a PUD boundary line. I'll remind the board, as you likely recall, that the periphery buffer was at 1.75 feet. It was then reduced to 50 feet, so all of these would be fences that were permitted within the periphery buffer.
You're just kind of reading down the list that's in front of us?
Chronologically, so it's not in the exact same order, but
Yeah, okay, you've got it dated also.
yep. 2005, 20 Farmstead Drive, there was a permit granted for a fence 15 feet from the PUD boundary line. 2007 at
I guess I
Yeah.
sort of object to the testimony, and I can state my reason for the objection.
Go ahead.
So I just want to refer the board back to its decision and order from this past December, January. So the way that we see it, the board's order was two-part. There was an order regarding discovery, which required the town to produce records that were created after March 17th of 2009 in the Beaver Creek PUD. That, I believe, was done, and it sounded like you were given a copy of what was produced to the Burrises. And then the burden shifted, so to speak, on Mr. Burris and Ms. Burris to, if they wanted additional records, they could go and look for them themselves. And I think, as Mr. Burris said, there was one record, the one from Beaver Creek, which I think is the first one on his list, which the town produced, and I believe everything else was based on their research. The town, I should say, the DRB also concluded that its interpretation of the court's decision is that at least the way we read it, is that the only relevant records were those within the Beaver Creek PUD after March 17th of 2009. So, our position is that the board should not be considering anything other than the Beaver Creek records after March 17th of 2009. And there's obviously quite a few records there, and if we need to go through them, if the board denies this initial objection, then we have another objection. Is there any questions?
As I recall, the request that we did have was very specific.
To Beaver Creek in the specific time period. That was what we asked the town to do, and the town did that. So now the question, I believe, before the board, and you guys jump in if you think, is what do we do with everything else that's here? Does it get admitted as evidence or not?
Well, the question is, what did the court order?
Our interpretation was that they ordered applications from the Beaver Creek, and we took that to give it a relevant time period from when the ordinance was updated.
I think the relevant text, and it's a specific conclusion in our decision, which appears on page 3. It's under conclusions, item number 3. And it states that the DRB concludes that the court's concern pertains to the past practice of approvals for structures within the perimeter buffer zone in the Beaver Creek neighborhood, PUDR, after March 17th, 2009, not permits for structures in perimeter buffer zones in every PUD in the town. So that I think is as I understand it, is the basis for council's argument that the board, having made that determination, that without changing that determination, that's the scope of admissible evidence.
If I,
Our position in contrast to that is indeed a quote from the court's July 9, 2018 decision on the merits. The court then went on in the judgment order that same day and used different language that did not limit it specifically to Beaver Creek, and instead said, for instance, if the town has a consistent practice of approving structures, including fences, within the perimeter buffer zone, this would greatly influence this court's interpretation of the bylaw and the present application. There's no mention of specifically Beaver Creek there. The town then filed a motion to reconsider that decision. The court issued another opinion in August 3rd of 2018, and again used the same language, which was not specific to Beaver Creek. And it's consistent, our interpretation is consistent with the logical explanation. Certainly the court isn't saying the bylaws only apply to Beaver Creek. The court is saying you have a rule that applies to all PUDs in Shelburne. If you're applying it differently to all of the periphery buffers in Shelburne, then that might be relevant to our consideration of what the meaning of the bylaw is. It defies logic that it would just be as to Beaver Creek, because the bylaw similarly applies to every other PUD in Beaver Creek, in the town. And so that's why we are seeking to admit examples of the court's application, I apologize, of the DRB's application of this particular bylaw to all of the PUDs, because Beaver Creek is not the only PUD in Shelburne.
and if I can make one additional point, the DRB's decision that references the order and quotes from the order doesn't note the reconsideration order. And I have up here a quote from that where they explain that they're further clarifying and elaborating on the order that you have cited to. The denial of the town's motion for reconsideration refers to the bylaws, not Beaver Creek. It again refers to the bylaws, not Beaver Creek. It refers to the interpretation of a zoning ordinance by municipal staff. That's not just Beaver Creek, that is all PUDs in Shelburne. Again, it talks about the town's interpretation. It talks about the town's historical understanding of the ordinance. That would include all of these permits that we're seeking to admit. Again, the interpretation of the bylaws. And I think this last quote is probably the clearest explanation by the court of what it is asking for on remand. And it's saying that there needs to be a sufficient record that shows how the town has understood and applied its bylaws. So that is why all of these records that we're seeking to admit are in front of you to comply with the court's order.
Is it, you can mention that there's a widespread practice on the part of staff or the DRB to ignore the setback requirements for fences throughout the entire town?
Not only for fences, for structures.
No, but I'm asking just about fences.
Yes.
So
That's what the records show.
Not just through PUDs, but through the entire town.
I haven't focused on anything other than PUDs because the issue before the board is PUDs. I don't think there is a setback requirement for fences due to 1980.6, so the only real issue that could arise is PUD buffers and whether fences are permitted within them.
Since 2000, looking at all the PUDs in the town, how many times has there been a permitted fence erected within the buffer zone?
That's what I was starting to show here. And these are all of the records in front of you of permitted fences within periphery buffers. And then, of course, along we come in 2017. And unlike every other time someone sought a permit for a fence in a PUD buffer, our permit application was denied.
I would also add, I would also add that this is not an exhaustive list. I came here and spent probably about 10 hours going through town records, searching the various files. I should note that the zoning office staff was incredibly helpful to me. And I identified a subset. This was not an exhaustive search. Quite frankly, at some point, I just couldn't keep spending time here digging through the records. But it is we would say, a sample of the history of how it has been applied.
If it's not an exhaustive search, then we'd object to it, especially since there's no way of knowing, based on what the Burses are representing, what else has been denied. And I do actually, if I can address, so I have what I've called Exhibit A, which I think technically is already part of the record, although I'm not sure that it would have been provided to the board. This is an excerpt from Mr. Burris's filing with the environmental court, his initial brief to the court, wherein he represents to the court that he was denied the ability, and some of you who are here will remember, and the record will reflect it, to submit, I think it's A through J, exhibits at the initial DRB board hearing, and claims to the court that that evidence will demonstrate that he's correct. And that's the highlighted, just so we're clear, I did the highlighting on there. And unless I'm incorrect, not a single one of the documents that the Burses present to the DRB today substantiates his position. In other words, there are no documents that he's presenting today that substantiates the position that he set forth in the brief to the court. So,
Can you explain that, please?
sure. So he indicates to the court that he wanted to submit a number of documents showing fences and other structures in the Beaver Creek PUD, and that he was denied the ability to do that. That's our reading of his position. There is only a single document in the packet that he is proffering to the court, to the board today, regarding the Beaver Creek PUD, and that has to do with the structure on his own property, which we're not contesting and have never contested, was wrongfully permitted. So his position, initial position to this board, as well as his position to the court, is unsupported by his own research. And further demonstrates that when the court was considering what was relevant and what wasn't, it was in a direct response to his position that he was denied the ability to offer that to the board.
But how do you respond to the claim, which I think will be made, is that as a matter of fairness, if people in other PUDs in the town, as a matter of custom, are getting exempted from the setback requirements for fences and other structures, how's it fair to start applying it to this particular PUD for this particular applicant?
Well, I don't know what his argument's gonna be, but I'm not aware of any evidence that anybody was exempted from another structure.
Or as a matter of practice, they were being allowed to put the structures in within the boundary line, within the buffer zone?
I guess it remains to be seen whether or not there's proof within the packet that that's the case. But again, we're relying on this board's own decision, which was rendered about a month or so ago, interpreting the court's decision as to what was relevant and what wasn't. And I think it was a unanimous decision of the
Can we
board.
put that up there so I can reread what the court requested?
What the court requested?
Right.
Yeah, so yes, we need to do that, and so that was an action that the court specifically gave us. So then what I think what we also need to understand is, are we limited to that, or is the applicant limited to that? I mean, clearly from the town, we were told directly to do something, we did that. The applicant went in
Right.
and did more research,
Right.
produced more evidence.
Which-
So the thing at hand now is, we have to look to determine if we want to include this.
Right. And I know at least when I was hearing this, and we were discussing the decision, my feeling was that we would give the applicant the opportunity to go after more information. Our
Yeah.
responsibility was to, the Beaver
Correct.
Creek.
Right.
But if the applicant so wanted to collect other information,
Okay.
that's why that was part of the decision.
Correct.
Could someone refresh my recollection as to where the date March 17th, 2009 came from? Anybody?
I'd be happy to. So in March of 2009, there was a structure on Dorset Street that was non-compliant, and as a way to bring that structure out of the non-compliant status, the town essentially decided that upon a certain date, March 17, 2009, any structure within the PUD buffer would be essentially grandfathered in, that it wouldn't be in violation of the bylaw anymore. From my perspective, I don't think that really makes much of a difference to the court's question here, because if there was a structure that was permitted before that date, then it was permitted in violation of the bylaw, and if there's a structure that's permitted after that date, then it's permitted in violation of the bylaw. It really makes no difference whether it was before or after that date.
And the added difficulty with that also is, as far as we know, at least from the search of the records, there wasn't a spreadsheet created on March 17th or whatever it was, 2009, saying, here's all of the structures that currently exist in the buffer that are unpermitted, but are okay now under the grandfathering. And so there's no way of telling whether a structure in Mac Farm was pre-2009 or post-2009. And so it's what you have in the packet there are not only permits, but also non-compliant structures that there's been no enforcement on. And so there's no way of telling when that fence was built pre-2009 and it's safe, or post-2009 and it's not safe, but we can't know that.
But if we agree with your argument and say, okay, you can put your fence up, doesn't the next applicant who comes in, who wants to put a fence up within the buffer zone, doesn't that next applicant say, well, I have to have it because you gave it to the most recent people who came before you? And doesn't that, in effect, destroy the regulatory pattern that's been attempted?
Well, I think our...
Let me ask the question another way. Is it possible, and I mean the question sincerely, because I clearly wasn't here, maybe Dean was and can comment, but is it possible that what the town was doing at that date was trying to end any risk of exceptions being made prior to that date, creating the outcome you just described, and that means a perpetual violation of a completely unenforceable bylaw, and was trying to start a new slate. Now, that's pure speculation on my part. Dean, were you part of that process so that you have a view in that one way or the other?
Do you swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
I do.
All right.
I was here in 2009, John.
And as you understand the change in the bylaws that occurred then, what was its purpose?
Well, to be as concise as I can, it's much closer to your description than the description that was offered by the Burrises. In that it was indeed an amendment that was intended to address the fact that there were structures that had been located in the buffer, either as a result of permits or that were located in the buffer without permits, or were issued permits but may not have been located exactly where the permitting officer thought they would be, and to essentially take them off the table as issues for the town, basically to grandfather them, but to establish the policy very, very clearly that from that day forward, the policy of the town, the intention of the regulations is that the buffer should be free of structures unless they're otherwise permitted in the regs.
If I could just briefly respond and go back to what I had shown before. Post 2009, there are still permits granted for structures within the buffer. So I'll skip ahead. Of course, a permit was granted for a shed within the buffer in our yard. In 2012, there was a permit granted for a shed within the buffer zone. In 2014, a member of the Planning Commission, who was at the time on the Planning Commission, is now on the Select Board, applied for and was granted a permit for a deck, and the permit application notes that it is.
I guess we haven't really resolved the.
Yeah, we have. So I have a question for the town. So I'm looking through this list here. Is there a training program in place for town administrators to understand what is or is not allowed by different zones? Again, if these are all in violation, what sort of training was given to the employees?
First of all, there's a lot of properties we're dealing with, so I would not, there are some of them that may have been in violation at the time that have since been grandfathered in because of the 2009 date.
That's fine.
But I mean, whether people are being trained or not, I think is besides the issue. The issue is whether the board should be considering these properties as part of the evidence after it decided that it didn't, that they weren't relevant.
Okay. Anything else from the town?
So that's our first objection, that the board's own decision interpreting the court's order is that these are not relevant, okay, except for the shed on the Burris' property. If the board disagrees with us on that, then we have another objection.
Okay. Anything from the applicant?
No, aside from just making one other point with regard to what this would show, the zoning officer who denied this permit, after coming and testifying in our appeal, the records will show, permitted another structure within the periphery buffer.
Which one is that on here?
That is the 2018 125 Deer Run application. So that'll be,
Got it. B18005.
yes.
Okay, thank you. Okay. Question.
So just to be clear, there seems to be a couple of differences, and I just want to say them out loud, so if I misapprehend them, you can correct me. Firstly, there's the difference over whether pre-2009 items should be considered. Secondly, it sounds to me like there's a discussion about whether it's any structure within whatever the relevant time frame is, or whether it's fences. And then the third difference is whether these are structures that were were built pursuant to permits, arguably improperly issued, or whether they were on the property through other means, and they grandfathered as one and simply illegal construction is another. So am I correct in identifying those three as the issues about which there's discussion?
I think that's a fair way to break down potential boundary lines.
I don't know that we have distinguished fences from other structures. If it's a structure and it's in the buffer zone, then it shouldn't be. And our position is that fences are structures.
Can I ask what is the enforcement and inspection process for the town?
No, I'm not sure I understand.
Well, if somebody builds something, I know when you build a house, you have to have a CO before you can move in. When someone builds a fence, is it ever looked at to see if it was properly installed?
I don't know the answer to off the top of my head.
If I could just briefly respond, as part of our request for materials related to this application, the town responded to a public records request where we asked for any zoning enforcement actions, and in the past 20 years, there have been 0.
Okay.
Okay. Any more? I want to have to make sure the board
No, that's fine.
has a chance to. All right, so my thoughts are, key is going to be what the board agrees to submit. And I think we're going to have quite a lively discussion on that. Is that something we want to do now, or do we want to do in deliberation afterwards? What do you guys feel?
Is the precise question before us whether these documents are admitted?
Yeah.
That's the first question.
That's the first question.
Or whether they're relevant.
Well, if they're not relevant, I guess we wouldn't admit them.
Correct.
But
Right.
In either event, I would just ask that they be part of the record of this proceeding, even if they're not entered into evidence.
Is that something we could do?
Let's see here. Rules of discovery and evidence.
Yeah.
That's, I'm getting Connecticut history. I don't have
Yeah,
Vermont history.
that's our understanding as well. I mean,
Yep.
I'm not aware of any form where if something is not admitted, that it becomes part of
Yep,
the
so
record.
rules of discovery of evidence, section 3, number 4, irrelevant, immaterial, or unduly repetitious evidence shall be excluded.
Got it, okay.
If I, the alternative,
I guess you did all the work. There's no date attribution attributed to any of these on the second page?
Well, these are unpermitted structures, so it's,
Okay.
without,
They just showed up.
without knocking on doors and asking people who may or may not have been the ones who
And-
built the structure.
And how did you determine these structures? How did you come to know these structures?
So the town provided Google Earth software, which Mr. Pierce was very helpful in explaining. He indicated that it was accurate up to a couple feet. There's in the section related to our shed, a line drawn that shows that the mapping software shows the distance between the shed and the property line at almost exactly 20 feet, and as you know, it was permitted for 20 feet, so I think it's generally accurate. So the exhibits in the packet that you have are essentially the satellite images using the town software showing the distance between the boundary line and the structures that were constructed on these various properties. And as to when they were built, I don't think that that's before you. From our perspective, it doesn't matter because they were built according to the town in violation of the bylaw, and there's never been any enforcement action for them.
Just to clarify that last comment, these are ones for which permits were issued?
We're not. So the second page of the
Were
index
not.
shows.
So if permits were not issued, what evidence do we have that the town had knowledge of them for purposes of being held responsible for not enforcing the regulations?
Well, I think I would make 2 points. One, I discovered these using the town's own software, and two, the assessor's office, if you go through the town's files, photographs, all of these houses and all of these structures, we saw photographs of many of these structures in the town's own files. So, you know, that would be one. And then two, you know, if you drive down, for instance, Spear Street and look along the boundary with Meck Farm, there's a fence that runs the entire length of the neighborhood in every single backyard. Town employees are driving by this every day. So I don't think it's really hidden from view for anyone. Okay.
But I'd like you to respond to my question. If we grant you this permit, what impact does that have on the next applicant who says the Burris's got theirs, why can't we?
Well, the issue that the court addressed in really the reason we're here is that these are relevant to the town's interpretation of its bylaw. And we had advocated that section 1980.6, which says fences are excluded from yard setbacks, applied to periphery buffers. The town's view is that that exception doesn't apply. And the court has said that town's interpretation of the bylaw in the past is relevant to determining whether or not the exception applies. And so if you decide that you know, the permit should be granted, that would be just like all of the prior permits that were granted, a view that the exception, which is in the bylaws for fences in yard setbacks, applies.
So if again, I'll ask the question another way. So in your view, since the 2009 action, according to you, in effect, should be given no effect as a wiping the slate clean period to address the concern my colleague here raised about how do you avoid the bylaw in perpetuity being unenforceable. That's consistent with your argument that any unauthorized structure, not just fence, back to the original date of the bylaw's adoption is relevant. But that brings me back to Norm's question. How if, assuming just for the sake of discussion, either by board ruling or court ruling, you prevail in this and there's a clear determination that the bylaws haven't been consistently enforced and therefore cannot be so enforced against you, how does the town ever end that?
It could change the bylaw to be clear that fences, that the exception does not apply to yard setback, to periphery buffer zones. The bylaw doesn't say that the yard set, the exception.
Do I misremember the court's opinion? I thought the court actually ruled that that language meant exactly what the town said it did, as written. The court was simply reluctant to enforce it without better understanding whether there was prior inconsistent enforcement of it. So there's not a lot the town can do with respect to improving the language, right?
Well, I guess I have two different answers. I think you're 100% correct with regard to the court's opinion. The court said that the plain language of the bylaws from its perspective precluded fences from periphery buffer zones. However, if the town's practice was to grant fences, that would change its interpretation, and it may view the bylaw differently and find that actually fences are permitted within the periphery
And if
buffer.
the town wants to end that judicially created exception, how does it do that?
Again, it would write into the bylaw that the exception in 1980.6C does not apply to 1933A3 or whatever the particular citation is, and that would end it right there.
Yeah, I guess, Norm, my concern with walking away from 2009 is I think we have evidence in the record from Dean that the town recognized it might have had a consistency problem here and tried to solve it the only way they knew how, by grandfathering all the inconsistent practices to date. Now, I think, you know, that doesn't address, as the property owners pointed out, some post-2009 structures that have to be dealt with one way or the other, and I'm not expressing a view on which way that takes the board, but,
Yeah.
but I'm reluctant to basically wipe out the 2009 effort, because I'm not sure, in answer to your question, what a town could do.
I feel like the tools are there for the town, as the court said, plain language, they believed it was there, however, but the town is just not doing that. I think it's really on the town. They haven't been enforcing the rules.
But if the board or the court rules that precisely because of that, this fence is protected, then what does the town do to prevent that from happening in the future?
Yeah, so, all right, let's have closing comments from,
I just wanted to walk you back for a second here, Board Member Hellman. There's been no proof that the town hasn't been enforcing anything as of yet, except for this one structure. Well, that's not proof of anything, that's just notes that Mr. Burris put together. That's not evidence that the board can consider. That, I mean,
I guess
I understand you want to
Okay.
believe him and that, but
okay,
there needs to be hard evidence that can be rebutted by the town as to what those documents mean. This is just a list that the
Okay.
Burris has compiled.
any closing comments from town?
Can
We-
I ask a question, a quick question? Mr. Pierce, how in fact did this 2009 revision take, was that part of a decision that was issued, or did we modify the zoning ordinance, the bylaw at that point? How did we memorialize this 2009, March 17th, 2009 date?
Well, the date
I mean, how,
is injected into the regulations when the amendment takes effect. So it's understood that there's a problem. The text is proposed to be amended. It goes to the select board. They
yeah,
adopt it.
So
And
this
so,
was actually an adopted revision to the zoning ordinance?
yes, I was under the impression that the record in the past for this proceeding had included the various versions of the zoning regs to show their evolution. But if that isn't the case, then they can certainly be provided where you would see that the text had been changed to make that
Just
clear.
wanted you to make it clear that
By the select,
that's
not by this board.
The select board adopts the zoning regulations, correct?
Okay.
That's how, I just want to make sure everybody knows that's how it took place.
So we have to decide what we want to put in, submit as evidence. Do we want to talk about it right now, or do you want to talk?
Yeah, so you can also recess the session or enter a deliberative session to discuss the contents of the evidence that's provided, then admit what is relevant and irrelevant
Okay.
based on your findings.
Okay. My personal feels, I am comfortable talking in a public forum about this, but if any board member is not, I respect that, and we can recess or do this in deliberation afterwards.
I guess my
Any
only
thoughts?
comment is that given the history of the matter thus far, it's not unforeseeable that this may end up back in court again. And for those purposes, I think to create a clean record, we should decide to admit everything submitted or not, noting the town's comment that actually all we're discussing thus far is a summary. We don't actually have any of the underlying record substantiating what the summary gives us. But all that aside, I think we need to decide what we're admitting and what we're not, and then look at everything that we're admitting and look at only that, so that there is a clear record when it goes to the environmental court again, if it does, exactly what our decision was based on, instead of kind of looking at everything and then deciding what's admissible and what isn't after we've already seen it.
One thing I would like to have is, I would like to have the specific action that the court asked as a separate piece of evidence.
Well, I think we have
So
a
it doesn't-
court decision in the prior record.
Well, in other words, the town was asked to produce records on the Beaver Creek, and that, I believe, is item 1 on this list. And is that correct? Oh, it's your list, I'm sorry. Yeah.
That is the
Okay,
warrant that was provided to us.
okay, so would you be agreeable that that clearly has to stand alone, because that is a specific deliverable the court asked for?
That was already part of the record in the prior proceeding.
Okay.
But we wouldn't object to it being a separate standalone.
I
We just
just wanna make-
incorporated it for the purposes
I
of,
understand that, okay. But I want to make it very clear to the environmental court that you've asked us and we're delivering that. Okay, so that's that piece.
I'm sorry, I don't want to belabor this, but I feel like I need to put this on the record now before the board makes a decision I don't want to ask the board to walk back a decision, but I'm going to state our other objections now, if that's okay with the chair.
Sure.
Okay. So the other objection that we have is that according to the rules of procedure, section 7C, I believe, any materials requested from or provided by an applicant at a hearing that has been continued shall be submitted to the Planning and Zoning Office at least 1 week prior to scheduled hearing date. The materials shall be included with the board's other meeting materials distributed on the Thursday preceding in a regular meeting. Any material submitted by the applicant less than a week prior to the hearing date may be cause for continuation of a hearing. So these were submitted, at least to me, and I don't know if they were actually submitted to the office, but to me at 3 o'clock today. It's 108 pages, I believe. I didn't count how many permits, but I think there's 20-ish. I think we have a right to investigate them and look through them. So if the board decides that it can't sustain our initial objection, we would ask that the hearing be continued to allow us to absorb. And then the third thing is, third objection is that even if the appellants overcome our relevancy argument, our broad relevancy argument, and even if they overcome this procedural hurdle, I think that we need to go through these one by one before they're admitted, because we're going to, even if we have to do it today, we're going to be addressing each one so that each exhibit can be fleshed out before the board, so you have a full understanding of whether it's relevant, what it applies to, and what it means, at least from the town's position. I think that's only fair to the town.
Sure.
So that those.
With each exhibit, you're referring to each permit.
Well, he has them actually. The Burris's have them with exhibit numbers.
Right.
So they I assume they would move to introduce, like, say, exhibit 3.2 for example.
Chair, may I also add that you could potentially recess this hearing until after a particular agenda item for this meeting as well, if just for the sake of running the meeting in a smooth and orderly manner.
So my thoughts are right now is the town needs to have time to digest this big stack of documents, so I'm kind of weighing more towards a continuance
Yeah, I would agree.
of this right now. So with the continuance, we have to have a specific date that we're going to reappear again. How much time does the town need?
When's the next available meeting?
The next meeting dates are March 20th, April 3rd, and April 17th.
There's room on the agenda.
There's room in the April agendas.
How much time does the town need?
The April agenda, what was April 3rd?
April 3rd and April 17th.
The 3rd's okay. Let me just take a quick look at my calendar. That the 3rd's fine for me.
I won't be here on the 3rd, so you guys will have to settle it. But it's gonna work from now and then.
No problem, we'll take it over.
All right.
I have a question.
Yes, sir.
Can we request things from the town at that same hearing?
We need more information. You could
I was
ask,
thinking more of enforcement information.
you can ask the town now if you want.
That can be requested at the moment as well
Okay,
for the
could-
sake of continuation.
Could we request that the town provide enforcement of any permits, any buildings that are within the buffer that they're aware of, that they enforced?
I think
you did that
I'm not trying to box things up here, but wouldn't it make sense for the board, before we ask for that to define what we're going to admit, because
We can't,
there are three buckets that we could admit, in my view, to summarize everything we've discussed thus far. One is we could admit only the particular PUD. The other is we could admit all PUDs, but only after the date that the town tried, successfully or otherwise, to clean up the record. And then the third option is all PUDs for all dates. And it seems to me that understanding which of those avenues we want to go down will define, certainly for the town's perspective, but maybe from the property owner's perspective as well, what they want to be prepared to discuss at the next hearing. But I invite comments from the parties on that.
I know for myself, I think the continuance is good because for me to really reflect on anything there, I have to go back and reread the court decision and then look at what we have here, and then I can make some decisions on what I think might be applicable or not. I couldn't do that now.
I'd like to make a motion to continue this hearing to April 3rd, 2019.
second? Second. All those in favor?
Aye.
Aye.
Okay.
Thank you.
Thank you, everyone.
Thank you.
Okay, moving on. That's yours? That's yours, that's mine. Okay, next up, application CU 19-03, also SP 19-01, continued. Does that mean it's continued to today or continued some other?
Today.
All right. Application by Nimra LLC for conditional use and site plan review to expand the pre-existing non-conforming structure. Property located at 2689 Shelburne Road is in the mixed-use district and stormwater overlay district. All right, Ravi, can you give us the high-level view?
First off, my apologies for not preloading it onto the flash drive and onto the laptop. And secondly, this is a request to expand a pre-existing non-conforming structure at 2689 Shelburne Road. Based on our records, the structure has been in existence since 1992 at the latest. The structure is possibly even older than that. The structure right now is 6,196 square feet. And the applicant proposed an expansion of about 844 square feet. One major note that staff has noted is that this is not a property that has been subdivided. There is, based on our files, a certain history with this property that the ownership is in a condominium. While the condominium is it's a legal method of ownership of a particular space, the land. The term, based on per Article 2 of the Town Subdivision Regulations, the term does not include condominium conversions that solely change the form of ownership of a parcel of land or structure without new land development, emphasis on without new land development. So staff would like additional review from the town attorney to discern the impacts of this condominium ownership and whether this type of land development would trigger the subdivision regulations or not. Other than that, in terms of the bylaws, staff has not noted anything of concern with the expansion.
Is there any way you can put it on screen? I remember what it is. We're talking about
The beverage place.
the beverage, yeah. All right. So we can share. All right.
My apologies once again. Yeah, staff has not noted any major concerns with the proposed expansion. The expansion is in line with Section 1920 with the property, as the property is in the mixed-use district. The expansion does not move the building any closer to the Shelburne Road right-of-way as it is right now. And there's nothing to note with the site plan, as no modifications for the site plan are being proposed at this point. Staff would defer to the applicant.
Okay, is anyone here to speak to this application? All right, please.
Apologize, I thought this would be about 6 seconds.
No worries. I'll have to swear you in?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth under pain of penalties of perjury?
Yes.
Very good.
I just want to hand you guys
All right. Oh, for the record, could you state your name?
the Hall Nasir,
Okay, thank you.
owner's son. So what you guys have right now was a rough drawing. I wasn't sure you guys need something that's kind of more accurate to what we're trying to do. Right now, the building.
I'm familiar with the front of the building. Could you
Yeah, it's a
maybe just give
little
us the
weird.
words?
It's like rounded off.
Just gonna square it off.
Yeah, so all that we want to do is just square the building off, just so it fits the rest of the building. I mean,
Okay.
it's a little weird that it was circled in the beginning, but
Okay,
work with what we got.
very good. Any questions from the board? All right. Questions, comments from the public? All right. Do we have any recommended language in there?
Is it possible to accept the application conditioned upon approval by the town attorney that the structure of ownership does not impact upon our decision?
Yes, that's what I was thinking also.
Okay.
Put that as a condition.
Yep, I think we'd actually talked about that.
Okay. Okay, so I'm gonna make a motion to finalize the record and close the hearing. You have a second?
Second.
All right. I'd like to make a motion for the staff to approve and adopt the language that, that the proposal is in compliance with regulations in effect due to the nature of the property ownership. So pending proper legal opinion from the town attorney, that we provide motion to approve.
Second.
All those in favor? Aye. So you can work with that, right?
Yeah, staff will formulate some language that
I
would
thought
make
you
sense.
might.
I think instead of pending, you probably meant subject, right?
Yeah, subject.
The idea is it's
Thank you.
conditioned on the town attorney's opinion that there's not an ownership structure.
Yep. Okay, you got that, Ravi? Okay, so you're good from us, and the town attorney's gonna check it out, make sure everything's good, okay? Very good, thank you. All right, moving on, application CU 14-01R4 / SP 14-01R1, application by SE Group on behalf of Lake Champlain Waldorf School Incorporated for conditional use and site plan review to change internal circulation, increase parking, modify stormwater management facilities. Property is located at 359 Turtle Lane and is located in the residential district. All right, we are preloaded, excellent. Okay, Ravi, kick us off.
So this is a proposal to change the layout of the parking area. It's the addition of 7 parking spaces to the parking area, improvements to pedestrian circulation, modifications to landscaping throughout the site, and the addition of 5 accessory structures for the existing school use. This is all in preparation for an expansion of student enrollment from 200 students to 257. Property is located at 359 Turtle Lane. It's in the residential district, and the property is 21.1 acres and an existing school use. Let's see, regarding this application, I guess to understand the scale of the amount of landscaping being added, staff has reviewed the documents and they intend to install 34 trees, 156 shrubs, and 306 perennials throughout the site. The site currently has 64 spaces, and the expansion would lead them to 71 spaces. The applicant plans to add 3 accessible parking spaces per ADA requirements. The site already has 26 bicycle parking spaces. There are changes to the lighting plan that, based on staff's review, is compliant with the with the outdoor lighting regulations under Section 1975. With this approval, staff has recommended conditions that the applicant must provide a 2-year performance bond or other form of security to ensure the landscaping is installed as proposed pursuant to Town Zoning Bylaw, Section 1900.5. At this point, staff will defer to the applicant.
Okay, is someone here to speak to this application? Come on up. All right, right hand up. Do you swear to tell the whole truth and nothing but the truth under pains and penalties of perjury? Thank you very much. For the record, could you state your name before you speak? And then, what can you tell us?
Adam Ports, landscape architect with SE Group.
Patty Hall, Administrative Director at the Lake Champlain Waldorf School.
You can just take the mic. Yeah, just take the mic.
Rick Bryant, traffic and parking consultant with Stantec.
There we go.
Probably keep this pretty brief. I think Ravi has kind of given a fairly good overview of what the project entails. We've been working with the Lake Champlain Waldorf School for almost a year and a half, starting with a master plan and focusing in on developing campus improvements related to both their parking area, pedestrian circulation, the playscape and field area of the property, along with the kindergarten area, preschool play area also. Really focusing on enhancing the campus improvements, making some environmental strides of improving stormwater treatment, water quality. Obviously, the campus is set in a very natural setting, surrounded by wetlands and environmentally sensitive areas. And we feel that the campus improvements have really strived to work with that landscape in a better way than what has been is existing there today. And that's been kind of the ultimate focus of the project, in addition to enhancing the kind of environmental and educational side of the experience for the school community.
All right, do we have any pictures? Say some words.
This is the pretty picture of the plan,
All
so
right.
to speak.
So
Graphically, kind of is the best view of what's happening. This shows the improvement to the circulation of the parking lot. If anyone has been out there now, it's fairly counterintuitive, and the drainage of the parking lot kind of all drains interior, making a pretty big mud pit.
Does that indicate pavement or what type of surface?
We're leaving it fairly open between gravel or asphalt. Obviously, the funding of the project is dependent on a number of things. So ideally, it would be paved to asphalt, but there is an option of having it just be gravel.
Okay. So from our perspective, that's just still an impervious surface, correct?
Correct.
Yes. Okay.
Kind of the key improvements within the parking area are both the pedestrian circulation, highlighted by walkways both along the perimeter here and in the intermediate island. We also are kind of improving the center of the parking lot by making it a green island that would have stormwater quality measures to it. Currently, today, it's all pavement. In addition to those improvements of the parking lot is the exterior lighting that Ravi had mentioned. There's very limited lighting on the campus currently. And obviously in times of December and January and February when it gets dark fairly early, having a safe environment for the school community to walk around the parking lot and get to cars is really important. So the exterior lighting is another component of that parking improvement. There's some cosmetic improvements to the front of the grade school building, improving drainage, and additional landscaping. A prime feature of the campus improvements is renovating the we call it the playscape, someone call it the playground. It's really a playscape, a multi-purpose kind of feature area that provides outdoor education, outdoor gathering, additional playground elements for all age groups at the school, and really is working to, pull these elements that exist within the wetland buffers out of the wetland buffers today. And very similar over in the kindergarten area is improvements to that playscape for the younger kids, and also integrating stormwater treatment that's contributing to improving the water quality coming off the site.
Try to get a sense of before and after, clearly the after shot there. Do you have some? Okay.
This is an existing conditions plan. The footprint of the parking lot is generally remaining quite the same from the perimeter. There's not any expansion to that. It's just reorganization and providing an interior greenscape to it. There's some adjustment to hardscape kind of around the grade school. And again, we've worked fairly long and hard with the wetlands department at improving and limiting, or I should say reducing the impacts to the wetland buffers that exist on site, and pulling those features into upland areas that would improve that experience.
Okay. Anything else?
I don't have anything else unless there's other questions, or Addie, you'd like to say anything?
I don't have much to say except that it all started with one rotting play climber, and now we are creating a lot of beauty and a lot stronger relationship to tending for the natural world, which is really a core value of a Waldorf school. So we're pretty excited to be able to do this kind of planning.
Okay, thank you. Any other questions, comments? Okay, questions from the board?
Yeah, I've got a few questions. Basically, around the report from Stantec, if you can help me understand some of the numbers, because what I understand from reading through this is you're projecting like adding 57 students, 14 staff members, but the parking spaces capacity is only increasing, I think, by 6 or 7 spaces. So when I think about that many more people coming, it doesn't quite jive with the smaller amount of parking. And then I was looking at your traffic study. You observed traffic one day, is that correct? So one day in May.
Initially one day. We after the initial survey, we've been back to the site several times for other purposes.
So I only saw one in there. And then then also you were going back to VTrans data at the intersection, and you pulled data from like June of 2012, which is a while back, and then also in July. I don't know how valid the July would be as far as peak demands, because certainly a lot of the demand of that intersection is due to the schools. So that doesn't feel good either about your projection that there's not going to be any impact on traffic when you're talking about 57 more students. That's perhaps 57 more parents and 57 cars, and what does that do at those peak times, which are bringing kids to school and picking them up? So if you could just kind of like help me understand with the numbers and how you arrive that there's no impact, would appreciate.
Well, we certainly didn't conclude no impact. What we did look at is the magnitude of impact that we would anticipate from the school, and it was basically, as you described, a straight line projection. If this many students is generating this many trips, what happens when we increase that by a percentage? So we made that forecast. Not every trip in and out of the school goes down to Route 7. We've got about 35% that come out the driveway and turn right. So when we look at the add-on and then distribute it, the number that spills out to the Falls Road, Harbor Road, Route 7 intersection is a fairly modest number, and we showed the state's counts for that location just to give you comparison to order of magnitude. With I think our bottom line number, we're somewhere about in the peak for the intersection, which is actually the commuter peak hours on the 5 to 6 p.m. time slot. School activity is negligible. Things really quiet down after 3 o'clock. So when you look at that commuter rush period, which is what VTrans would have us do, where we subject to Act 250, we're adding fewer than 20 trips. We're adding less than 1% to what's there. And you're right, we're comparing to a number that was counted in the summer months. We looked at the available data. There's a 2012 count and a 2017. We referenced the 2012 because it actually seemed to be a higher count. And the reason we have summertime counts available is VTrans hires interns over the summer, and they send them out to count cars. So that's when we can readily collect data. Granted, the school activity would be higher during the school year. The other traffic on 7 is really higher in the summer months. If you look at most, unless you're on a ski area access road, most any count location in Vermont where you see the variation by time of year, you see that summer is the peak activity period. And that's because people are on vacation, they're visiting, kids aren't in school, so the people are out doing errands and volumes just increase. So when we look at what's going on around us, we typically would look at summertime condition as the worst case.
But can so if you took the, say, the July traffic study and you were finding, I think I heard the peak is towards the commuting hours, like 4 or 5 o'clock in the evening. But wouldn't that peak potentially shift if you were doing the traffic study during when school was in session?
I recall we looked at some of the counts are often done 12 hours, 12-hour day, 6 a.m., 6 p.m. I recall looking at that, and it seemed that the school peak period was actually lower than what's happening at 5 o'clock.
Okay. Any other questions from the board? Okay. How's the board feeling? Oh, I have to open up to public. I'm sorry. Any questions, comments from the public? How's the public feeling? Hanging in there. Okay. All right. Absolutely.
We have contacted the Nature Conservancy, who's an adjoining or adjacent property owner. They actually have, I forget the specific language, but they have some type of legal agreement to review any improvements on the Waldorf school property as was part of the sale. So we've received a letter of support from them. We've presented this plan to them. They are in support of that. We're happy to provide that to the town. I don't have that on hand, but we have received that from them, and they are thumbs up on what the school is doing.
So unless you're putting more lights on, and I'm assuming those are all going to be dark night compliant or dark star compliant. Yeah, I didn't see any specifics on that. Did I say something wrong?
Did we get a,
Dark star, oh yeah.
did we get a, lighting photometric plan? Oh, we did, yep.
Yes, the photometric plan is in the set of site plans.
Okay.
And you're comfortable that this meets the...
Staff is comfortable with the lighting plan provided in the cut sheets.
Okay. Great. All right. So I'm gonna just throw it out there and make a motion to finalize the record and close the hearing. A second?
Second.
Make a motion to approve, direct staff to prepare a decision indicating approval of CU 14-01, to condition that a zoning permit be required prior to any land development. Applicant provide a 2-year performance bond for the landscaping. I don't believe there's anything else we thought. No? A second. All those in favor? Aye. All right, congratulations. You're welcome. Okay, moving on. Application SUB 18-01 by Paul Ewing for final plan review of a proposed 5-lot residential plan unit development. Properties at 300 Cheese Factory Lane is located in the Rural District, Conservation District, and Floodplain Overlay, Watercourse Overlay District.
I missed one, Jeff.
No.
Liam Bisson.
Oh, man, I put a check mark there. I'm sorry. Yeah, I was on a roll. All right, let's back up again. Application CU 19-03, SP 19-03, application by Liam Bisson on behalf of Novembrus Property LLC, Shelburne Veterinary, for conditional use and site plan review to expand in existing conditional use. Properties at 3053 Shelburne Road, located in the mixed use district and the stormwater overlay district, and I apologize for that. All right.
So, this is a proposal for a 750 square foot addition to a previously approved conditional use, repaving of an existing parking area and the addition of 2 bicycle spaces. Subject property, 3053 Shelburne Road, mixed use district, stormwater impaired watershed overlay district. The lot currently hosts a veterinary clinic. Regarding the addition and the conditional use review, staff does not foresee any issues with the proposed addition in terms of impacts. The addition would be compliant with Article 10 of the town zoning bylaws regarding dimensional requirements. One thing that the DRB may look into is regarding landscaping. Specifically, landscaping materials must, regardless of season, obscure the views to the extent that no more than 1/4 of the proposed building, parking and loading areas, dumpsters, or utility boxes are visible from viewpoints on the residential properties, including first floor windows, doors, and porches, and associated decks or patios. Other than that, staff finds the applicant to be in compliance with the zoning regulations currently in effect, and at this point, staff will defer to the applicant.
Very good. That's right in. Do you swear to tell the whole truth, nothing but the truth under pains and penalties of perjury? Excellent. What can you tell us?
Basically, I'm wanting to expand my business.
Okay. So can you show us a kind of a before and an after?
This is, what you're seeing right now is the before. We have an after. I don't know if it's on, if you all have the
Yep.
same.
That attachment includes all 3 plan sets, so
Am I-
you can just
should
scroll.
I-
Yeah, you can just scroll down.
That would be the new setup. The idea is to add probably 700 square feet approximately, maybe 650 to 700, to expand the building within the existing footprint.
Within the existing footprint.
Meaning I own the land, so I'm going to
Right.
expand out.
Are you going beyond the freezer? How far back does the freezer go? Is that 15 feet that you currently have now?
It's 300 by 150, the property.
The structure.
How do you mean?
I noticed on the before picture, you have a freezer that shoots out the back.
The freezer that is going to be eliminated,
Right.
and we're gonna incorporate that inside the building.
Okay. And is that freezer currently kind of equivalent to that top red line there?
Yeah.
Indicating the outside
Yep.
boundary of the structure? Okay. Anything else you'd like to add?
Not really. That's
Alrighty.
about it. Just want to expand my building a little bit so I hired a new vet, and I am growing the business and want to make it bigger to accommodate more people and more business.
Okay. Any questions from the board? Any questions from the public? Yes, sir. Come on up. Swear you in and state your name.
Neighbor. Mike Taylor.
Do you swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
I do.
And your name is?
I'm Michael Tamlin, and I'm one of the owners of the house abutting the vet at 71 Holcrest Lane. Should be really quick. We probably could have just, if I could just call you, would have been fine. But we wanted to know if there was any changes to the plan to not cut any of the trees down behind the property and decrease the thickness of the woods between our property and yours, if we would be notified about that. I know that in the document it's quite clear, it's explicitly clear that there's going to be no change to the landscaping, but if there's a change to that, would we be notified? Would that be a change to the application? Number one. And number two is if you plan to put any windows or any other ways to be able to view through the back in the addition, like would you be potentially looking into our property from back there? I don't know if that's something that would matter to you.
I can answer this very quickly. I have no plans to cut down any trees or install any windows that would impact your property.
That is it.
Okay. Any further questions, comments from the public? Last round for the board. All right, someone want to make a motion? Oh, go ahead.
Go, all right. So then I would make a move to finalize the record and close the hearing for applications CU 1904 and SP 1903. I would also make a motion to direct staff to prepare a decision indicating approval of the aforementioned applications by November's properties, with one condition, that the zoning permit is required prior to any land development pursuant to 2010.1.
Second.
All those in favor? Aye. All right. Very good, thank you. We got correct placement of check mark. Moving on to application SUB 18-01. Application by Peter Ewing for final plan review of a proposed 5-lot residential plan unit development property at 300 Cheese Factory Lane, located in the Rural District, Conservation District, and Floodplain and Watercourse Overlay District. All right, Ravi?
Now I know where it is.
This is the final.
Just to give a better sense, so what I have displayed is the entirety of the property, the Ewing Family Farm Trust. This is, at least in Shelburne, 101.56 acres. It consists of 3 sections, Section A, B, and C. Section A will consist of a residential PUD with 3 lots. Section B will be conveyed to the Nature Conservancy as open space. And that is 48.1 acres in total, 38.6 acres in Shelburne. Section C is will be conveyed to Vermont Land Trust, and that is 45.1 acres. And so you have 2 parcels conveyed as open space, 3 parcels that will be developed as residential units in Section A, therefore totaling 5. So onto the residential portion. If I can load it, will be clustered as, oh, was it right here? Oh, it's right here. Will be clustered as such, providing access via South Burlington to the 3 residential units. So with Lot 3 proposed to be 6.54 acres, Lot 3 is to the north abutting South Burlington. Lot 4 to be 6.01 acres, Lot 5 to be 5.21 acres. Private water and wastewater will serve these properties. At the moment, staff will
point out that that we like this layout. The lot layout is clustered, which would minimize potential impacts on nearby agricultural lands and open spaces, which is consistent with section 1930.3 C and also the town comprehensive plan. Regarding the open space and all legal documents, staff recommends a condition of approval requiring the town attorney to review all legal documents by the town attorney. Furthermore, with the right-of-way being through South Burlington, staff also recommends a condition of approval stating that the decision is effective only when a final plat for the proposed PUD has been filed in the City of South Burlington land records. Just to add an update to this, this PUD was reviewed and approved by the South Burlington DRB yesterday evening, and a written decision is impending. So with that, that condition, that a plat would be impending as well. In addition to this, the staff also recommends that the applicant provide a copy of the state stormwater permit prior to any zoning permit application, and also that the homeowners association bylaw should include the maintenance of all stormwater management systems in the proposed PUD. Likewise, I just showed you two different plats, if you didn't notice. So one of the plats is by Kitteridge Land Surveying, and the larger plat is by Civil Engineering Associates. Staff is okay with this arrangement that's provided by two firms. Staff understands that this proposal is a synthesis of both of these plats. So the applicant is responsible for recording both this plat, which is provided to you as a drawing number P1, which does not have an orthographic image, and also the plat that has been prepared by Kitteridge Land Surveying. Only when both plats are recorded and both plats are recorded at the same time will the subdivision in whole be recognized by the town. Other than that, at this point, staff will defer to the applicant.
Peter Ewing. I just noticed one thing that's we didn't see, and that is for the whole farm, there should be...
Oh, yeah, thank you. I swear you in.
Oh, okay.
Yeah, thank you. Do you swear to tell the whole truth, nothing but the truth under pains and penalties of perjury?
I do.
Thank you. I was engrossed in your layouts here.
The plat of the Ewing farm that showed all the greenery was accompanied by a final survey by CEA that takes away the natural features in the greenery, and I thought I had provided that to Ravi. If I haven't, I certainly get it to him.
It's in their packets, right? That's it.
That's it.
Yep.
I just wanted to make sure you had that. Okay.
It's just that this looks pretty.
Okay. I can just give a little bit of background that you've heard it before, but I'll just very, very quickly wrap it up. And, this project, my father, John Ewing, and my mother, Linka Lee, had been, divorced for 45 years or more. And so the farm was jointly owned by them. And, nothing happened during their lifetimes. But towards the end of their life, they finally came to agreement that they needed to do something and agree upon something. And the first thing they did is contact the conservation groups, and of course our farm is pretty much surrounded by conservation land. Nature Conservancy is to the east, and Nature Conservancy is to the south. Vermont Land Trust is to the west, and now, just recently, Vermont Land Trust is now to the north, so we're pretty much boxed in by conservation land. So that kind of drove the whole thing. And so the Nature Conservancy was interested in parcel B. The University of Vermont came in and did a natural area assessment, and that's what they decided that really fit into their plan. And then the Vermont Land Trust was interested in parcel C, and they were less interested or not interested in parcel A, and that is because it's just primarily rocky, kind of a hilltop, no real natural features, and not suitable for agriculture. Just happens to be closer to the road, and so that's how things kind of played out. Do you have any questions? I don't have much to add other than that. We've gone through everything. Stormwater came along a little bit later than everything else. I've had my hands full just, meeting the application requirements in South Burlington and Shelburne, getting everything done, our wetland approvals and everything. And so stormwater came along about 2 weeks ago, and we jumped on that, and we hired Fitzgerald Environmental Associates, and they're handling the stormwater, and so that's moving forward as quickly as possible. Other than that, your approval is required in order to close with the Nature Conservancy. We'd hope to close within a few weeks. We'll see how that happens, but talked to John Benhammer at the Nature Conservancy today, and he thinks that they'll be ready by the end of the month, hopefully.
Has anything changed in the layout or anything since we saw it last?
Yeah, one thing, if you want to go, one small thing, it has to do with stormwater. If you want to go back to our site plan. So our road was, originally our road kind of swung this way. And then due to the layout and the topography, we realized in talking to the engineers, we realized if we swung the road this way that we would create more space for stormwater management, basins, swales, and such. So we did that, and we think that just works better, and from a number of reasons. So that was pretty much the only change that I can think of. We recently updated the setbacks and verified that those are correct. Can't think of anything else that's changed, Robbie.
Nope. Yeah.
Okay, any questions from the board? All right, questions from the public? Yes, sir. I'm gonna have to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
Yes, I do.
Excellent. Could you introduce yourself?
Mark Saunders. I'm the property due west of the project.
Okay.
So I have several questions. Number one, the plan shows hardwood trees planted along the road, according to the town street plan. So those get planted at the time of the road construction, or do they get planted at the time that the lots are sold by the owner?
So can you be more specific?
Is that the site plan?
Where are we
I
talking?
think I have that one
Yeah,
in
it's
there,
not
but
It's on the site plan.
Some C2.
C2.
Yeah, that was a recent change to the site plan that Robbie discussed with me. But I don't see it, well, I can point to where it would be, if you could ever get it to the right.
It's all along the road.
Yeah, so according to your landscaping, Robbie had the trees planted along the road.
This is
Shows
in.
both sides on the plan.
Yep. Yep.
I have to push back on that, but I don't know if I was successful. And the reason why is because we have a management plan that was done by the U.S. Department of Agriculture that we, about 10 years ago, and we continue to follow that plan. And we basically created, like insect habitat and bird habitat. It's not coming to mind, but it's like
Yeah, the forestry habitat.
no. This was an open field, an open meadow, birdland habitat as opposed to forestry. And so we were working with Danny Pete out of the Wilson office of the USDA. We continue to brush hog that meadow and keep it open. So filling it with trees wasn't something I wanted to do. Ravi pushed me into that, and I'm sort of used to getting pushed around now. This project goes through 2 towns, so we just go with it.
Yeah.
Requires it?
This was discussed at preliminary plan review. This is pursuant to Town Subdivision Regulations, Section 810, Subpoint 4. Hardwood shade trees must be planted on both sides of streets or private ways where no trees in a manner consistent with Town of Shelburne tree policy currently exist. So this project triggers this requirement.
This is a tree-lined road.
Yes.
If it's a requirement, we'll do it.
Construction. So that occurs at the time of construction of the road?
I would hope after all that's done, that'd be like one of the last things, but that's not my call.
Yeah. This can be conditioned in with the last certificate of occupancy for the houses or at any point, but in terms for staff monitoring and evaluation of something like this, doing this at certificate of occupancy stage would be best.
Okay, certificate of occupancy of initial?
It can be initial or final, it's up to the board.
Actually, I would suspect in the real world, the right answer is that it depends on the time of year. If the CO is going to be issued in January, you're not going to want the trees planted then.
Yeah, I guess I was more concerned with whether Peter has to plant those trees when the road is put in, which would be well before these lots were sold, or would it be at the time of completion of the sale and the house and things like that?
Bobby, I'm assuming your position is that they have to be in by CO, because you don't care how much early.
Yeah. Yeah, in terms of maintaining landscaping, past practices have been for the first CO of a development, for the last CO of a development. It really depends. For something like this, it can be conditioned as, that landscaping must be installed prior to the first certificate of occupancy for the development.
Subject to seasonal variation.
Yeah, I mean, but again, in the real world, planting trees, it's going to depend on the time of year.
Okay.
And is that the responsibility of the homeowner then? Or?
It'd be the responsibility of the developer.
Okay.
Yes.
And also, stormwater is now an issue. That infrastructure, from the discussion we've had, there's gonna be swales and retention basins and so on and so forth. So that is gonna take a precedence as well. So we'll see what the final plan looks like for that. And, for example, there was some talk about, having a ditch alongside the road as part of the, swales or basins or whatever. So obviously the trees couldn't be in the, close to that or even have their roots in the ditch or anything like that. So we'll have to get that worked out, and then I'm sure we can get something done for with the trees.
All right, would it be too vague, I'll throw this out to the board, would it be too vague if we say stipulate within, based upon first occupancy, subject to seasonal impact type of thing?
We need to specify. We know it's a requirement of the regs. I'm pretty confident that Robbie's department can enforce the regs unless we have a reason to know otherwise. They're shown in the plan.
It's possible.
So you'll figure it out. We don't want them planting trees in February, okay?
They can if they want to.
They can.
Do we have a requirement here for bonding these trees or no?
No, but that can be easily arranged pursuant to section 1900.5.
Yeah.
I don't know what that is.
What was that?
Not 1900.
To the
Bond,
tree?
in the town, there's a requirement to provide a 2-year landscape bond, so that if the trees die within the next couple of years and he sells off and disappears, then there's a bond in place to pay to replace the trees. It's just surety so that the trees get planted and stay alive for 2 years.
What's the mechanism for bonding? I've not been involved with that, so I don't know what that
You can do it a couple ways. Robbie can tell you how to do that.
Easiest way is to establish a certificate, a line of credit with a bank or a security deposit that would that covers the cost of landscaping over a 2-year period. So making you or the developer responsible for landscaping, the installation of landscaping within 2 years. And then if the landscaping isn't installed within 2 years, then we take that line of credit, we take that money, and then we install the landscaping accordingly.
Okay. I mean, if the board, insists on doing that, and then of course we'll do it.
I mean, it's a requirement.
Yep, for landscaping, yes.
Oh, so well, I guess I'm surprised by that, because it wasn't, I haven't heard that yet, and it wasn't in the write-up. The other thing I would say is that, that Lot 2 is going to belong to me. My brother owns the lot to the other side. We're not going anywhere. This road is gonna be done right. The stormwater management is gonna be done right, and the landscaping is gonna be done right. We're not going anywhere, but if you want a bond, then we'll do it. Okay.
Okay. Any other questions?
Second question, the fire pond has appeared on the final plans, and it seems like it's serving two purposes, the fire purpose and also stormwater. And I couldn't remember whether these houses need a sprinkler system, because I know last night discussion was that Peter's house on Lot 2 in South Burlington will have a sprinkler. So couldn't remember whether.
I have the answer to that question.
Okay.
No.
Yeah, I don't think Shelburne.
Yeah, that's why I was wondering about the fire pond. Okay.
I was on the phone, we've been talking with John, the deputy fire chief, and I was on the phone with him probably for 45 minutes today. He did all the talking, I did all the listening, and he told me how it's going to be done. And the question did come up about the sprinklers, and I talked about South Burlington, and I'd been told by our other consultant at Fitzgerald that sometimes if you have sprinklers, you don't have to do the fire pond. So I raised that issue, and he said, no, we want the fire pond. Right. We're insisting upon it. Right. And he said nothing about the sprinklers. He didn't think that they're effective. He said they'll save lives. They won't save any property. Just gives a person a few more minutes to get out of the house, but it's not a sufficient amount of water to actually save the property. So he didn't think it was. I guess he wasn't really in favor of those. Sprinklers.
Final. So in one of Peter's documents, he said that he hopes that this project and everything is completed in 5 years. There's no expiration to the approval of this plan, so that if it's not done in 5 years. It's in perpetuity?
No, there's no true expiration of these plans as long as the conditions of approval are followed through and the plan is followed through accordingly, yeah. So
Okay.
once they have the first zoning permit, the plans are pretty set.
Gotcha.
Anything else?
Nope.
Okay. Any other questions from the public? Last chance for the board. Applicant?
No, we're excited to move on. We can't close with the Nature Conservancy until we get our permits. And so, that's our next big priority, of course, following stormwater.
Okay, you want to make a motion?
Make a motion to finalize the record and close the hearing together with the motion to direct staff to prepare a decision and indicate a final plan application for SUB 1801, prepared by Peter Ewing for a 5-lot residential plan unit development with the following conditions, and I am not going to read them all. They are 1 through 10 as written, but I would add as number 11 for the placeholder, the bond for the landscaping. And I'm sure Ravi can come up with the correct text for those purposes.
All those in favor?
Aye.
Aye. All right, very good. Thank you. Okay. Have fun. Mr. Vice Chair, it's all you.
We're out of here.
I'll be over in the other room.
Okay. Are we gonna have a conversation after?
Yes, we are. Yeah, we're coming back.
All right. You're fine. So we are on to item number 10 on this evening's agenda, which is application SUB 1302R3. This is an application by Shelburne Green LLC for preliminary plan review and site plan review. Property is at 120 Graham Way. It's located in the Commerce and Industry South District and the Stormwater Overlay District. Anybody who's going to testify this evening, I need to swear you in. Let's get it all done at one time. We've got 1, 2, 3, 4 people swearing in. I hereby swear or affirm to tell the truth, nothing but the truth, under the pains and penalties and perjury.
I do.
Thank you. So we are here to take new testimony this evening. Ravi, do you want to tee this up a little bit for us, or?
Yeah. First, I'll just read documents that you have received in your emails prior to this hearing. If you need a physical copy, I can hand you a physical copy.
Yeah, if you,
Yeah.
I would take one.
Yeah.
I forgot to print them.
So that's comments from the rescue chief. I also have comments from the fire chief that were received today. And then I have these materials provided to staff on February 28th, last Thursday, after the packets were finalized. In addition to these materials, I also have a letter from Clark Hinsdale that was provided to me this morning regarding his attendance, and also to correct an item from the hearing, from the previous hearing. I also have in the written testimony a letter from Ian Rutherford and Marjorie Rutherford that was received February 4th that I seem to have forgotten. My apologies. And that I will bring to the attention of the board. Other than that, this is a continuation from previous hearing that was heard on February 20th. And so during the February 20th hearing, there were certain items that the board would like to have had in their disposal. Okay, thanks. Including comments from the fire chief and rescue chief, as well as the memo from Clark Hinsdale that was provided to me in early January, which was received, I believe. And in addition to that, one point that staff would like to note is the changed outdoor lighting plan, which is a revision based on staff comments, which reduces the luminosity of many of the wall pack lighting, and staff finds that this proposed lighting is in compliance with Section 1975 of the town zoning bylaws. One item that staff would like to turn the DRB's attention to is a point made in the application materials, the memo provided to you for the February 6th meeting regarding the role of the comprehensive plan in your decision-making. This was a point brought up by the applicant's counsel, and staff finds that this should be revisited if they believe that this is pertinent to their review of the application. At this point, staff will defer to the applicant.
All right.
Very good. Dave Marshall from Civil Engineering Associates, appearing on behalf of the applicant, Shelburne Green LLC. And I think Revi has done a good job as far as trying to summarize where we came from as far as the last meeting of many meetings before the board. And what we're trying to do is close out preliminary plat so that we can then in turn pull together the final details as part of a final plat application. In regards to what we heard the board ask as far as some staff review of the proposed circulation plan, and what we have in this particular location in the southern portion of the Shelburne Green South project is a reconfiguration of the parking and the circulation pattern. Originally it was a U shape that ended in a cul-de-sac. Actually, we feel that this is a much improved circulation pattern in that regard. and the reports back from both rescue as well as the fire chief seem to indicate, I won't try to interpret their words, but nonetheless that this is acceptable. There are a number of recommendations from the fire chief as far as, again, emergency response components, knock boxes, and many other aspects that are common for every application. They did ask specifically to basically make sure that this particular location maintained 30 feet of pavement width to enable equipment to basically make that particular turning movement. And that's one particular thing that I think literally the engineer says we're within inches, 7 inches of compliance. So making that particular adjustment as part of a final plan application to the board, we're very comfortable with. So in summary, the staff report from Chief Ouimet, the applicant is comfortable accepting all of his recommendations as part of conditions and moving forward with the application. Let me just kind of go back. Mr. Hinsdale, unfortunately, can't be here tonight. He's serving in a similar role to what you do as far as the zoning board in Ferrisburg. And one thing that we have shared more information with Mr. Hinsdale, and he's starting to be more comfortable with the long history that this project has had. And in fact, as I look at the board members here, probably Mark's the only one that was around for some of the original discussions in regards to what was considered to be an acceptable accessory use size, and out of all that, something that we weren't looking to relitigate, and the board at the time also had come to the conclusion that if it's small enough, it's not a restaurant, it's simply a support service to the rest of the PUD. So we were hoping not to have to go back and relitigate that particular discussion, only because the board had spent a considerable amount of time providing their own level of comfort and in essence precedence as far as what was considered to be accessory versus what was considered to be a full-fledged restaurant. So that was a little bit of past history, some of what Mr. Hinsdale was starting to had talked to you about at the last hearing as far as his representations as far as where a restaurant could and couldn't be. Our take is, again, this is not a restaurant. It is simply an accessory use in support of the rest of the planned unit development. So we're open to questions from the board at this point in regards to trying to pull together the last of the information. I think Revy did a fine job in his staff report as far as summarizing where we were and what has been brought together in the meantime. Some of it, including the department head reports, came in at the last minute, so I don't know if there's any formality that you need to do in order to accept those documents. But nonetheless, we're in a very comfortable situation. The more important thing is making sure you're comfortable with where we're at, and with the understanding that there's yet one more bite at the apple as far as a final plat application, that we would like to have the opportunity to go in that particular direction. But before we can do that, we're open to questions from the board.
To add to this, staff has also discovered there is additional written testimony from Thibodeau and McDonald from 134 Covington Lane that was received February 4th. Let's see what else is in this folder. I think that's it. My apologies.
Can you just outline the changes in the lighting plan real quickly? Are you familiar with the specifics of that, or?
Well, the thing
maybe Ravi knows more than.
Well, he's always on top of it, so we'll leave it at that. So bottom line is that we certainly had some illumination issues as far as excess luminance, and also specifically on the facades of the buildings, some of the building mounted lights exceeded specific written standards within the lighting portion of the zoning bylaw, and all of those have been toned down. The applicant is not proposing to have in place security lighting. We will be opting for motion detection to basically have lights come on in lieu of having full 24-hour, no, we wouldn't be doing 24-hour, but at least full nighttime lights. as part of a system on this particular property. So we felt that that was a better balance in regards to this transitional area next to the residential uses on the east side of the property. So those were some of the primary changes that this particular lighting plan had. Obviously, the luminaires and the luminance levels, I think, are highlighted in the staff report. But again, things that we were working on was just choosing lighting levels that made the most sense in regards to, again, some of the reflective components. It's one thing when it comes back off the ground. It's another thing when you're looking at a vertical surface, i.e. the wall washing of buildings with light. So in this particular case, the town zoning bylaws were quite clear that we didn't quite meet those standards, and the new application, or the new design, I should say, does do that.
Thank you.
I have to apologize. I have read everything, but I'm not sure I understand as much as I should. In reading all of the regs, I find this is not even listed as conditional use. It's not listed as, you know, a cafe is not under any of the uses. So I'm trying to figure out how the decision got to the point where it is okay in the building.
So this is quite a history. If you turn to this material provided, the applicant has provided the original decision, findings of fact, no decision from 2015, in which condition number, let's say 7, from this decision states, further, any food service activities conducted under the aforementioned 2,500 square foot allowance may operate between the hours of 6 a.m. and 6 p.m. only, Monday through Sunday. Further, such food service activities shall not be located within buildings 8, 7, 12. So,
No, I got that part. I read that part.
yeah,
The question is, how did we leap from not a
Yeah.
conditional use to, I mean, I just,
yeah.
just to get my head around how we go from it's not allowed to it's
Right.
okay.
So back to the regulations, Article 12 of the regulations allow restaurants as a conditional use within 200 feet of the Shelburne Road right-of-way, and accessory food service uses that serve a PUD like this.
1210.12.
Yep. Accessory uses including retail and other services. Food services accessory to a principal permitted use where service is clearly subsidiary to the principal permitted use, or in the case of PUDs, is clearly subsidiary to all other uses in the PUD. Thanks, Dave. And so, yeah,
Food service.
yes, food service,
Supplies service to the,
yeah,
to the area.
Yes.
As an accessory.
as an
Right.
accessory.
So are these to be not, okay, so I'm trying to go from this to, or is the public going to be allowed in the space?
The applicant has indicated that, yes, the public would be allowed into this space.
So, okay, sorry, I'm not trying to be difficult, I'm just trying to figure out how, if we're talking about following the regs, how we can go to an ancillary food service, accessory to principal permitted use, all the way to, we're gonna have beer and food for the public. I just,
Yeah.
sorry.
Staff would refer you to the number of staff reports produced in the last 6 months regarding this subject that clearly defined, clearly subsidiary, and also with accessory, that's something that's incidental and subordinate to the entire PUD.
Okay, that's fine, just, it's more a precedent
yeah.
question than it's going to be, I mean,
Yeah.
it always comes up as it's almost like a fence, right?
Almost like a fence.
Let's not talk about that.
I just, wanted not to back into an answer without having the question.
And that's fair. And, there was a lot of work done by the board as far as that particular discussion point to, I remember even Dean saying, what is accessory? I mean, there was even a question internally, and is it as something that's only 49% out of, and the other half is 51%? Obviously, that was not where the board wanted to go with regard to considering what's accessory or what's supporting versus the other major component.
Sort of like, yeah, what portion of the mission of that function out there, brewing beer, is actually for actually serving patrons? You kind of
Right.
look at the size, you know?
And that's the key component in regards to ultimately what the board spent a lot of time talking about was, you know, is it a 5,000 square foot facility? And they said, holy cow, you know, that's taking on a character that is more than what we think is appropriate for a support service. Can the public walk in? Well, there's the whole Shelburne Green facility. People can walk into any one of those things.
Right.
And in this particular case, they could walk into this 2,500 square foot area. And at that time, the board had basically drawn a line in the sand saying, this is basically as big as you can get without tipping the issue over. So that was done with a lot of thought and a lot of back and forth and a lot of what
I'm
works.
good with that. I have one more quick question then. Bijou Chocolate was in a similar space, so my question is, under what category did that fall?
Right, so with the other retail uses, retail spaces, that falls under condition 7 of the original approval.
Even if it is food?
So this is, again,
Yes.
staff would refer you to the number of staff reports produced in the last 6 months regarding this issue that this is something that we have publicly said that we cannot condone due to the fact that it does not follow with the comprehensive plan, that it would supersede the primary uses in the PUD, that it could lead to, as you've insinuated, that other uses that are food manufacturing could also operate in a similar capacity. The integrity of the PUD here is what we see at stake. This is a manufacturing district. This is a manufacturing PUD. It's not supposed to be a food court. And so staff refers you to the staff reports regarding the subject that we do not condone this type of expansion of hours as we see it as superseding the intent and integrity of the PD as well as the district.
Okay, thank you.
Not a problem.
But for the record, with respect to this accessory use, are you just expanding the hours of operation or changing the actual size and delivery of food within the
Good
space?
clarifying question. No proposed change in the size. We're looking for the original 12-hour band of hours that originally started at 6 in the morning going to 6 to go from 10 to 10. And in this particular case, a further clarification is that any food service would stop at 9 o'clock. People could still sit there, but the activity of serving food would stop at 9. So that's a further clarifier or further restriction on the band, the 12-hour band that we're currently authorized for.
Will this modify the current space that's right on Shelburne Road, Route 7, where you got Felino's and Fiddlehead side by side now,
right,
serving each other's goods. Is that going to continue?
We have no control over that property. That's actually a separate out parcel that's owned by a separate entity. So this particular discussion.
It's not really relevant to the.
No, I just wondered if they're going to move what's currently on Shelburne Road into that space was where I was going.
They haven't really said.
I think Mark summarized it well. I'm not sure of exactly what their plans are as far as that's concerned. And that whole other parcel is a whole separate parcel.
No, I know that, just in terms of operations. Okay.
Any other questions of the applicant's representative from the board?
No.
All right.
More questions, if I could, to help me understand. In our last meeting, there was testimony from Mr. Hinsdale, and he had a drawing that showed that the restaurant could actually be located within a 200-foot zone from Shelburne Road. So I trying to do some research to figure out if I could actually answer that question, and I couldn't answer it. Can it actually be built within 200 feet? I couldn't come up with something. Is that an option?
Technically, from the zoning standpoint, maybe due to the PUD buffer on the periphery that does not allow any structures within that setback. So if
I apologize, I don't recall exactly what the final wording was, but the original intent was to enable existing structures along Route 7 to be repurposed for
Yes.
restaurant use.
Built by a certain date.
Yep.
In
was
that,
my
in that
recall.
buffer zone.
actually,
Exactly. And
if
there,
you
you
ref-
could
yeah.
see the structures, there are a fairly limited number that would be eligible under that particular proviso.
Actually, if you refer to the memo provided by Mr. Hinsdale, the spaces identified are actually outside the buffer, but are compliant within the 200-foot rule. So, because if I turn your attention to that memo, the spaces in orange are not only in compliance with the zoning regulations, but also outside that buffer jurisdiction. That a structure with some sort of how do you say, some persuasion, would be the least non-conforming solution possible for a restaurant.
But I understand the applicant's position to be, this is not a restaurant.
Right.
Correct. Yep.
So it doesn't count.
Yes.
I guess, question for Ravi. I know that in your staff report here, there's some statement here that I think staff believes that this does not comply with 1210.12.
Yes.
Can you help me understand that? Because when I read it, it says accessory uses, food services, accessory to the principal permitted use.
Yeah. So, how to put this in the best way possible? With accessory uses must be incidental and subordinate to the primary uses on the property. From staff's understanding, incidental and subordinate also have definitions in the zoning bylaws, but this is essentially meaning that the accessory use isn't a phantom limb. So it shouldn't stand alone by itself without the PUD. That the primary uses of the PUD is essential for the operations and maintenance of the accessory use. That without the PUD, the accessory use can't stand alone. It's like a shed. A shed is an accessory use. Without a house, does a shed really have value? It's tied directly to the house for the use of the house. And so that's how we treat this type of restaurant as well. Yep. That during the hours of operation, should the accessory food service use be in operation, and that if the operations are not, if the primary options, if the food service, if the manufacturing is not in operation, then that food service use should not be able to hold itself up, if that makes sense.
But Ravi, if I could, wouldn't that same consideration have been taken into account by the DRB back when it approved the accessory use?
Staff would hope so.
All right.
Yeah. This decision was drafted for my presence, and I was not at this table staffing those meetings. So my understanding was that staff was well aware of the impacts of an accessory use like this and the possibilities. However, at the time, from my understanding of staff at that time, this was a PUD for manufacturing in a district for manufacturing.
And commercial activity.
And commercial activities.
That's why I'm wrestling with is the accessory use, because, my understanding from previous testimony was that this is primarily there to support the business, the brewing business of Fiddlehead, kind of as an accessory use to what they're doing there, similar to what Shelburne Vineyard does. I think they've got, I don't know, I've never been there, but tasting areas and whatever, and it's very typical of what craft breweries are doing around the state of Vermont. It's like, that's part of their business model now is, I'm gonna brew beer, and oh, by the way, I'm gonna have a little tasting room where people come in and taste their beer, maybe grab something to eat. And to your definition of accessory, if the brewery wasn't there, if Fiddlehead wasn't there, I don't think they'd have this.
Yep.
So I feel it conforms to accessory services as I read it. I would be very interested in hearing from the neighbors, because I do understand their concern about the noise issue. And we've gone from 10 to 9. I think I just saw another letter, maybe it was from the neighbors suggesting some different hours, I don't know.
who wrote the letter was
Yeah, so,
Well, we'll open it up to
Yeah,
public
that-
testimony.
that's where I'm at now.
Again,
Yeah.
we're here to take new testimony, is any of the applicants, attorney, Norm, would you like to, I'll let the applicant speak first, if you have anything else to say, and then we'll open it up to public comment. I did swear you in, didn't I, Norm?
Yes.
Thank you.
Norman Stanislaus, property manager, Shelburne Green. To answer Mr. Hillman's question, we have successfully completed an agreement with the Gables Board Association in reference to our current application and plans submitted before you this evening. I do have a copy of that executed agreement, if the board would like to take that into evidence at this time.
Okay, so this is new, this was not included in our package?
have a few more copies if you want me to, excuse me.
I think it would be pertinent and relevant. Does anybody have a problem reading this and considering taking it into evidence? Okay, yeah, if you would.
as long as they don't need a fence.
So what was provided to you is unsigned, and then this one is the signed one.
Okay.
from my understanding.
Okay.
Sorry, there's at least one more.
Is this the same
that the
thing that
same
was
thing?
sent to us, it just wasn't executed?
There's, on the agreement page, which is page number 3,
Yeah,
the verbiage has changed slightly.
okay, because I did read this, so. if
That's
you
the
could
only
just-
thing that's changed is the agreement page.
All right, can you summarize the changes for me, or is it quite a bit?
Yes. So basically, what had happened is the Gables Association wanted to make sure that they were not agreeing in perpetuality, that they were agreeing to this. So what I did, as far as the change is concerned, reading down through, it says Shelburne Green LLC and the Gables Association Inc. Gables hereby execute the agreement on the 6th day of March 2019 and pledge that in exchange for Shelburne Green pursuing the project components identified in items A through J in the Shelburne Green's February 6, 2019 letter. The Gables does and will support the project currently proposed and submitted on the current application and plans before the DRB. So that was added in. Currently proposed to submitted on current application and plans before the DRB as of this date.
Okay.
And a part of Shelburne Green's preliminary plan application materials submitted to the Shelburne Development Review Board on January 18, 2019, the proposed project. The parties further agree that if Shelburne Green receives final DRP approval for the proposed project as currently submitted before the DRB Board, and that language was also installed, as currently submitted before the DRB Board. And the approved project incorporates or allows for items A through J identified in the letter, the Gables will not appeal or otherwise object to the proposed project.
Okay, thank you.
Okay.
Anything else?
Can I see a copy of that?
Anything else, Mr. Stanislaus?
No, thank you.
Okay, thank you. Any questions of Mr. Stanislaus?
Yeah, before I go too far away. If a interested party other than the Gables Association takes an appeal from a decision, if it's granted in your favor, do you see this agreement still being in effect, or will it be?
I see the agreement still in effect, but that person, as a member of the Gables, would have the right for an appeal.
So if a individual members of the association takes an appeal, you will still feel that you are bound by this agreement?
Yes, that's correct.
Thank you.
All right, anyone from the public who would like to speak? All right, Ann?
Thank you. Ann Powell, presently president of the board at the Gables. We've worked long and hard over many months, as probably most of you are aware, and certainly many of us here today are, to come to an agreement. And it came right down to the last moment. Norm and I communicated a lot today. The change that he read on that last page was the piece that we were holding back on some because we wanted to be sure that it was saying if we agreed, we could not appeal this plan that's in front of you folks today. Because, of course, I'm sure you're aware, and I have become very aware, there's yet more steps to come. And if by any chance there were changes they made at that point, that we would still have the right to appeal if necessary. We also had asked the question whether, the same one that you asked, which was, this was the board agreeing for the association, which is within the board's purview, but if there are individuals who own residences there and want to appeal because they don't like something we agreed to, they do have the right to do that. So it's not, it doesn't shut them all down. So consequently, we did sign because Norm had gotten the language changed around from what lawyers like to put in there, which I'm sure you're all very familiar with, and we felt comfortable. Given the choice from the very beginning, for those of you who have been here, and Mark, you've been here since 2014 at least, you know that, if it were our choice, we would change a number of these things, but sometimes you have to compromise.
Thank you. Would you like to run for Congress?
Pardon? No. This is plenty for me.
Is there anyone else who would like to provide testimony? I need to swear you in, sir, or did I already?
Well, I had my hand up.
All right, well, you're good then, thank you. All right.
Swear me in again.
No, if you use the mic and identify yourself, I'd appreciate
I
it.
need it.
No, you're good.
I'm Ian Rutherford. I'm one of the proprietors of a condominium in the Gables. I'm one of the newest members of this team, and if I had realized, of course, when I bought this property in September, that this was all going on in the backyard, I would be somewhere else today. So right away, that's sort of a comment. I'm not completely happy with the deal as the board has put it together. I mean, the board is doing what they think they want to do, and they've tried to make some compromises. And I somehow think that those compromises are not right. And I'm particularly concerned about the fact that you have a zoning, and without going back to the numbers, but Rafi can give me all of those, the position of the restaurant is clearly outside of any of your rules in the town. And it is indeed a restaurant. It is not just a cafe. It is not a canteen for the employees in the development. It is a restaurant, and it's just not a place for a restaurant. It's an industrial park, and it's a good industrial park. But it is not a place for a restaurant. Your rules don't let it be a place for a restaurant. And because it's a brewery, you're basically getting a beer hall. And if you don't think that it's going to be a beer hall, I'd like you to take a look at the Burlington Free Press article, what was it, about 4 or 5 days ago, on the current opening of the new beer hall in the Foligno's Fiddlehead building. And that is a big noisy place. Go in there at lunchtime and it is not a quiet, comfortable little spot. And for neighbors just at the other side of the wetland, and our condominium is probably the closest one to the building that you can get. So I'm definitely an NIMBY here. But this is, I think it's a problem for the board. If you start changing the rules because it's convenient for the brewery, yeah, it's just not going, it's just not on. Anyway, that's just a general observation.
Is that all you have to say, sir?
Yes, I'm saying that I'm not comfortable with what the board has said, and I'm quite familiar, not with Shelburne. I'm a new resident, as you know, but just to put it into perspective, at one point, about 10 or 12 years ago, I was developing some land in Ferrisburg. I've been through problems with the rules and regulations that we face in the state, and I ended up by being on the other side of a lawsuit that went before the environmental court, and we won. And so I think that this is overstepping the rules. And I understand why they've made a compromise, but I don't believe that that's the right thing to do. And I've made my comments.
Very good. Thank you, sir. Is there anyone else who would like to make any comments? Any more testimony? All right. Anything else from the board?
Chair, one thing I'd like to add is that in the agreement, there is a reference to concerts and special events. Per their approval right now, concerts are not allowed in the PUD. For anything that's not explicitly included in the approval, it's not allowed in the PUD, and staff would have to regulate it. Whether that's something that the applicant would like to request, whether that's something that that the board would like to negotiate, I'll defer to the board.
We've talked about that many times, and we are well aware that it's not in the purview of the DRB and so on, but in our negotiations, we wanted to put that one in there. We know how to go about it, and we will continue.
Okay. And your position on that again, Robbie? Just run that by me once more.
If special events, concerts, if that's not in the approval explicitly, then it is not allowed in the PUD.
Right.
That is staff's view on this.
Right. So they can have whatever they want in their agreement over and above. I don't see where we really need to regulate that agreement with regard to that. But it's a separate issue between the applicant and the town.
Agreed.
We're really not a party to that agreement specifically, so.
Dave Marshall. No issue with the chair's position as far as trying to enforce an agreement. I guess what I'm more concerned about or trying to understand is that I've heard previous testimony from the town that indicates that special events are exactly that they can be enabled by certain legislative bodies in town, which I understand is the select board, and that because they're special and limited in number, that they will often exceed the performance standards that are set forth as expected operational levels of any use in town. So that's why I'm kind of interested in understanding For example, across the street at Shelburne Museum, when they have their concerts, and the people at the Gables get a free concert. Sorry, it's just editorial. Just how that works. So I heard Revy basically say, is like, hey, Dave, if it's not in your PUD approval, it ain't happening. So that's what I just kind of want us all to understand, what we can and can't regulate, and what is special and what falls within the PUD and what doesn't. I'm just trying to understand myself too, not dealing with special events myself, as far as, again, just how is that handled?
Well, you referred to the performance standards, and I think those.
No, I'm not so much concerned about performance standards. You know, embedded in the many piles of documents that have been provided to the board is a sound study that talked about, again, what the expected noise levels were at the property line, and that was done even prior to the. Let's see if no, I'm not going to find it. So. That was done prior to the, here we go, the final location, or the currently proposed location of the accessory use at this particular point. Again, the thing that we always had talked about in the big picture was using the U-shaped buildings to basically corral the noise and try to force that back towards Route 7. In this particular case, by actually connecting the buildings, which was previously an open area, we've basically, again, utilized not only this particular corner feature, but also the back half of the building as further insulation of noise moving in the easterly direction towards the Gables. So we felt very comfortable with regard to at least performance standards for the uses on the property. But as far as the special events, so-called, you know, the applicant is not specifically proposing them. We have a tenant that would like to have perhaps a limited number of special events, and those hours of operation and when they occur is subject to whatever the town feels is appropriate. Obviously, there's a side agreement that basically has brought that discussion into the agreement with the Gables if nobody at the town wants to regulate them. Not saying that's the case. But at the same time, if Revy is saying today that the PUD can't have anything unless it's specifically written into your approvals, then out of respect of what Matt Cohen at Fiddlehead has expressed an interest in doing, granted not having them go until 10 a night, 11 a night, or 12 a night, but basically stop at 7 o'clock. I just wanted to basically have an open discussion of, you know, what is, you know, where do we have this discussion if it does have to be embedded into the PUD approval at some point in time?
Yeah, I'm not certain
I've overstepped my bound.
I'm gonna let council respond to that, but
Well, I just want to clarify. I think what Dave said is not incorrect.
Can you
anyway.
identify yourself just for?
Peter Raymond.
Thank you, Peter.
Our interpretation of the zoning regs and the permit condition is that it doesn't speak to nor regulate those special events if and when they are to occur. It's through a separate application process, and it's on individual basis decision whether to grant or deny is those permits, but the baseline being that a approval is needed from the town, but it's not, there's no use. We're not seeking any approval for a use or a structure or anything related to that. And as the agreement, while for special events, maybe much more than Matt Cohen or Fiddlehead or anyone in the PUD is needing, 4 would be the limit, but that's between the Gables and Shelburne Green, and it's a kind of a distinct and separate process.
Okay. I suspect that's probably something maybe you may want to take up with staff over the course of the next days and weeks, and get a determination. I'm not sure we're really the regulating body here, so I understand your concern, Mr. Marshall, but I'll let you work that out with Revy and council, and we're kind of getting out of our arena here on that. So, any comments regarding that from the board, or questions, or okay? So we've taken a lot of testimony on this project over the past 6 years, 5 years, and I'm inclined to think that we're probably going to want to deliberate on this. So I'm going to make a motion to close the hearing at this point, and the board will then deliberate at its convenience and see where we come up to as a board.
Second that motion.
All right. All those in favor? Aye. Anyone opposed? No. So, thank you for staying with us till 9:30. And like I say, we'll be meeting up to discuss this. Won't be tonight because we have some other things to discuss with our reclusive members. And thank you.
Thank you for your time.
Hey, Norm, would you do me a favor, please, and go tap Jeffrey and John on the shoulder, if you wouldn't mind? Thank you.
You can't talk to him. You can't talk to him.
Yeah, you can't talk to him. You just gotta
No, we just say hi.
just ping him. Give him a little knock on the knob.
Mark, who changes the zoning regs? We don't, right?
Planning Commission.
Planning Commission, okay.
The Planning Commission
Okay.
takes that up.
Because there's been a lot, just at a meeting,
They're the policy setting board. We're the quasi judicial board.
there was a group of, they're working on this whole tasting room theory, which is a big deal.
We ought to probably have this discussion.
No, I'm just saying, I just heard it,
Yep.
that it's going to the state and it's going through the legislature.
It
So
is,
it's a big deal.
It's become a huge thing for the state of Vermont.
Another check mark, flipping over. Other business, all right. Anything while we're still in session that we want to talk about before we deliberate on our items?
Yeah, when are we getting more cookies?
Yeah, come on.
This is important.
They
They were really good. They were really good. All right.
And there's no beer.
Can we have a motion to adjourn?
Thirsty when we talk about
So moved.
All those in favor? Aye. Thank you. All right. Let us know when we're done.